what is the insanity defense? I think there's a tremendous amount of misinformation and confusion about this. And I'll start with a principle that I tell all of my students, and that's in one of the first pages of my book. And that is the mere presence, absence, or severity of any mental disorder does not by itself make a legal determination. That's very important because people think that just because someone has bipolar disorder, just because someone has schizophrenia, just because someone has an organic brain syndrome, that means that they are insane. And that's not the case. So here are the criteria. There are actually two criteria that are used in the United States and most Western countries. One of them goes back to 1843. This is known as the M'Naughton criteria, and it comes from a historical case where a defendant named Daniel M'Naughton attempted to assassinate the British Prime Minister at the time. Instead, he seriously wounded an undersecretary and was arrested and was found by a court of judges back in 1843 as suffering from a mental illness and being not sane at the time of the crime. And much like what happened after the Hinckley verdict, where people were incensed at the fact that John Hinckley was acquitted, not guilty by reason of insanity after attempting to assassinate President Reagan, 150 years earlier, there was a hue and cry, and Queen Victoria herself convened a panel to determine standards for insanity. And they came up with the M'Naughton criteria, which is still the standard used in about half of the states in the United States today and many Western countries. And what the M'Naughton criteria says, that in order for you to be acquitted on the grounds of not guilty by reason of insanity, at the time of the commission of the crime, and that means not before, not after, but at the time you committed the crime, you have to be mentally incapacitated, you have to have a defect of reason and behavior, and it has to be by reason of some mental disorder, by reason of some mental disease or defect, so severely impaired that you do not understand the nature and quality of your act, and even if you do understand that, you do not understand that what you're doing is wrong. So basically the criteria are, whatever the status is, it has to be at the time you committed the crime. Because remember, you may be arrested, it may be a year until the case goes to trial. Now you may be fine. You may have taken your medication, you may have recovered somewhat, but that doesn't mean you didn't have a severe illness at the time you committed the crime, or vice versa. You may be extremely disturbed right now, but maybe you weren't that way when you committed the crime a year ago. So we've got to go back and take a little psychological time machine back to the time where you committed that crime to determine what that status was. And at that time, your powers of perception and behavior and control have to be so impaired that you did not, and there has to be a disease or defect. And what the law means is you can't just say, I was impaired. There has to be a diagnosable syndrome. In order to qualify for an insanity defense under M'Naughton, there has to be an actual syndrome that's been diagnosed by a medical or psychological professional. Schizophrenia, bipolar disorder, it has to be something that is recognized by the medical community. And so that's the second criterion. The third is it has to be so severe that at the time you committed that crime, you literally did not know what you were doing. And even if you knew what you were doing, you didn't understand right from wrong. What that means is you did not know by the prevailing laws and standards of your society that stabbing someone to death was wrong. Doesn't mean that you just thought it was right. It doesn't mean that if somebody insulted you or stepped out with your wife or girlfriend or robbed you of money and you got so mad at them that you thought that they deserved to die that you decided to kill them. That's not what it means. It means that you literally did not understand that society condemns stabbing and murder as something that's wrong. And if you think about it, that level of impairment is an extremely high bar to meet. There are very few conditions that make you that impaired that you literally don't know what you're doing and know that it's wrong. Well, we'll get back to that in a moment, because the second standard is what's called the American Law Institute standard. And this only goes back to the 1960s. And that says, very similar to the way M'Naughton starts, you need to have your mental faculties impaired. It has to be some recognized disease or defect, otherwise known as a diagnosis. But here, the criteria is you did not understand the wrongfulness of your act, and that's similar to M'Naughton, but where the ALI standard differs is in what's called the volitional prong. That is, it says, even if you did understand that what you were doing was wrong, you were not able to control your act. And that's different. If you think about it, the first criteria we use, McNaughton, doesn't say anything about your ability to control it. It simply says it's what's called a purely cognitive prong. It simply says that you didn't understand what you were doing, you didn't know that it was wrong. The implication is, if you literally don't know what you're doing, that you can't control it. But ALI says no, even if you know right from wrong, there's a compulsion. You have no choice. You have lost your volition in being able to control your actions. And again, very few psychiatric disorders cause that level of impairment that a person cannot control themselves. So, a mistake that many of my colleagues often make is they diagnose, or they see a diagnosis, or they confirm a diagnosis of bipolar disorder, schizophrenia, post-traumatic stress disorder, and so on, and they say, okay, well, that means a person must have been insane. But what's very important for examiners to pay attention to is what happened during that crime. That's why it's very important to talk to witnesses, very important to get the defendant's recollection of what happened, read the arrest reports, read what's in the motions that the prosecutors bring, because, to put it mildly, just because you're crazy doesn't mean you don't know what you're doing. So evidence that the individual planned the crime, evidence that they sought to cover up the crime, evidence that they sought to evade capture for the crime. I may have schizophrenia, but if I wait for you to come into the room for hours, jump on you, kill you, then try to dispose of the body and run away and not leave any evidence, that pretty much shows I know what I was doing, didn't it? It pretty much shows that I knew that it was wrong, because why would I run away? So again, it's very careful not to misconstrue having a mental illness with therefore being not guilty by reason of insanity. But it works the other way too. Because remember, we don't want to give the impression that people with mental illness are all these potential crazed killers, because they're not. The rate of major felony commission, including murder, among people with serious mental illness is a little bit higher than the normal population, a little bit, but small. We're talking in 5 to 10% ranges. So it's not like we have to be afraid of people with mental illness. In fact, people with mental illness are far, far more likely to be victims of crime than they are to be perpetrators. So it cuts both ways. If you think about the different competencies that the law provides, if you're a otherwise unimpaired person over 18 years of age in the United States, you have a range of rights that you take for granted. You have the right to consent to treatment or refuse treatment. You have the right to make a contract, to buy and sell property, to get married, to get divorced, to raise children. Nobody questions these rights. In fact, if somebody wants to take those rights away, the burden of proof is on them to prove that you're not capable of doing these things. That's why these people who say, well, I'm going to have you declared incompetent and take your rights away. It's not that simple. It's very difficult to do that. But by the same token, the law says, let's work it the other way. You have a responsibility to behave like a civilized person and obey the laws and rules in the society. And if you violate those laws, if you commit a crime, then you can't just sit back and say, well, I was impaired, so there's something wrong with me. I have schizophrenia, I have migraine headaches, I had a bad toothache, therefore I'm not responsible. No, then the burden becomes upon you to show why we should not hold you responsible. And that's very important in considering the insanity defense in general and forensic psychology in particular, because they both deal with fundamental psychological, legal, and philosophical issues of responsibility, volition, and morality.